Welcome to Law Sessions. I am Jennifer Housen. In this law session, we will focus on answering contract law examination questions. Now, this session, of course, assumes that you have knowledge of the syllabus. It also assumes that you have either watched all the law session videos in the series or, at the very least, completed your reading for the syllabus. Because the entire session is focused on how your approach to answering contract law questions should be taken. Now, in the first of the 4 segments, we will consider general approach. In the next 3 segments, we will dissect a contract law question. The 3 areas that I've chosen for us to do this are contract formation, which we will do in the second segment. And I've chosen that because this will usually be the first question on a contract law paper. We will also review a question on misrepresentation. And finally, we will review a question on mistake. The questions I will use are real questions which are taken from the University of London External LLB program over the last 10 years. I've assisted hundreds of persons with examination preparation for their LLB exams. I've assisted them with their New York bar exams, and I've also assisted them with law school entrance exams. Now, having completed my own LLB and postgraduate diploma in law in the UK, and having sat the New York bar exams and completed my professional qualifications in the Caribbean as well as in the UK, I can say to you somewhat safely that assignment and exam writing is something I am well familiar with. So you are in fairly safe hands at the moment, as have been many of my prior students. Now, it doesn't matter how many hours you spend studying and revising, the law examiner will not know that. He meets you, or rather you meet him, one time for 3 hours on paper, and you have to make it count. Now, you may be lucky enough, of course, to have some type of formative assessment. But that said, the vast majority of exam law questions are still done in the traditional style of the end of year 3-hour exam. Now, the 2 biggest criticisms of law exam candidates are 1, they do not answer the exam question, and 2, poor time management. Now, as it relates to not answering the exam question, the examiner says that the law students do not answer the exam questions. The law student will, of course, disagree. As far as they are concerned, they have just come out of a 3-hour exam and they wrote for 3 hours, so they must have answered the question. So how dare them get a bare pass mark? Well, you, the law student, as well as the examiner, are both right. The law student did answer the exam question. He or she just didn't answer the exam question the examiner asked. Now, what do I mean by that? Well, there is the exam question asked by the examiner, and there's the exam question answered by the examinee. There's a book that's called Men Are From Mars and Women Are From Venus. Well, the title might just as well be Law Examiners Are From Mars and Law Examinees Are From Venus. Because if I had $1 for every time a law student said to me, I don't know how I failed contract. I felt really good going into the exam. I felt good after the exam. All of my topics I studied for were on the exam. In fact, I thought I'd failed some other subject, CLRI, but I got a 60 in that. Well, if I had $1 for every time I heard that, I would be a very rich woman indeed. The point is, an examiner will ask a question such as, consideration lies at the heart of English contract law. It is an essential ingredient, or it is an essential constituent of any valid system of contract law. Discuss. The problem is, what a law student reads is, what is everything I can possibly remember in the area of consideration, and write it all down in 45 minutes? And that is what they answer. So, they answer that question briefly mentioning consideration as part of English contract law, and completely ignoring the heart of English contract law bit, or the essential ingredient or constituent of any valid system of contract bit. So the point is, you must answer the question asked. Now, I must admit that sometimes, and I have read law exams, law exam questions. I must admit that sometimes the exam question is written as if the exam writer is living in a parallel universe in his own head. But if you read the question carefully, it does actually make sense. What you need to do is to consider the question as a legal hypothesis and dissect it for legal principles. Do not try to visualize the characters as actual persons and the situation as something in real life. It is not. It is a hypothetical situation constructed to encapsulate legal principles for you, the law student, to identify in context and answer it. Now, as to the second criticism of poor time management, I want you to understand the significance of poor time management. If you have 4 questions to complete in 3 hours and you decide to do 2 to the best of your ability, you don't need to be a mathematician to realize that even if you wrote each answer worthy of a law lord, you simply cannot get more than 25% of the entirety of the marks for each question, so you cannot get more than 50% of the available marks if you only do 2 questions. So by doing 2 questions, you're already setting yourself up to get a reduced percentage of the available marks. So if you can address these 2 main criticisms, you are more than halfway there. Now, starting with the latter first, how do you deal with time management? Well, one of the biggest mistakes I see law students make is to spend hours and hours only reading. I will say this: I have never met the law student who didn't have the knowledge and pass. But I have certainly met the law student who has had the knowledge and failed, because the knowledge by itself is not enough. The primary piece of advice that I will give you about time management is this: if the first time you are writing under timed examination conditions is in the exam, you have already failed yourself. Because in your preparation, what you need to do is to ensure that you write out in full at least 1 question to a past exam question from your university, and write at least 1 under timed conditions. Now, it can be the one and the same. If you are sitting an examination of 3 hours in which you are required to write 4 questions, then you have 45 minutes per question. But that is not 45 minutes of writing time. You will need about 5 minutes to prepare the question. You will need another 5 minutes to reread the question. So effectively, you have about 35 minutes of writing time. Before you go in the examination, you should know exactly what 35 minutes of your writing looks and feels like. So some examinees will ask me, Jennifer, how much should I write? Well, unfortunately, I can't tell you that. You need to be able to write 35 minutes worth of answer, is what I can tell you. Because if you practice and you know a topic with which you are extremely familiar and which you are prepared for, and you can write, say, 6 sides of A4 sheet, then you know personally that that is the very best you could ever do in an exam. So you ensure that in the exam, after you have written 4 sheets, you keep an eye on the clock to make sure you're on target time-wise. Because if the best you did when you had done a dry run without being in the exam was 6 sheets, then you should be able to then know that by the time you get to 4, you really should look at where you are. That is your time management. Now, what about your question answering ability? Well, first, if it is an essay question, make sure you read it at least twice. You have enough time to do that. Then consider, what is it that the examiner is asking me? You should not just see, for example, a frustration question or a consideration question. You look at what exactly about the area of frustration or consideration the examiner is asking. Then you answer the essay question logically, meaning you start with a path and then you go to a definition. Or you can start with a definition and go to a path. Then you set out your arguments in favor of the position advanced, and then any arguments against your position, and then you conclude. Now, one of the ways to stay focused in an essay question is to keep referring to the words in the question. Then it means that you are answering that question, the question asked by the examiner, not just a misrepresentation question, which is a general everything I know about misrepresentation type answer. In an essay, read the question carefully to make sure you understand what is required. Look carefully at the keywords and phrases which indicate the sort of answer you're expected to give. Now, very few essay questions, if at all, require you to merely set out a factual description of what the law is. You will almost always be required to analyze the factual content in some way, usually highlighting any problems or gaps in the law, and you may have to possibly suggest reforms. Now, if a question asks you to analyze whether consideration lies at the heart of English contract law, it is and carries on to say it is an essential constituent of any valid system of contract law, you should not write everything you know about consideration and finish with one sentence saying the consideration is essential for a valid system of contract law. Instead, you should select your relevant material, and your whole answer should be targeted at answering whether or not it lies at the heart of English contract law. So, for example, highlight situations where you can have a validly formed contract without consideration, and equally highlight cases where the consideration requirement has not been so strict. Example, cases like Pawan and William and Buffett Brothers at the very least. What about problem questions? Well, these consist of facts, usually with the direction to advise X, who will usually be one of the parties. Now, the aim will be to analyze the facts, to identify the legal issues, and analyze the law to find the relevant legal rules. Next will be the application of the law to the issues and reaching a conclusion. What you should remember is the acronym IRAC: Issues, Rules, Application, and Conclusion. Now, some law schools go on Clio, which is practically the same. You start with the claim, you look at the law, you evaluate, and then you consider the outcome. Now, this is general advice on how to approach a special type of exercise to which law students have been subjected to from time immemorial, whether in seminars or exams. You look at the problem type exercise. Now, looking at IRAC, it must be that you write so that when you come to the end of your answer, the entirety of the thing follows and flows along IRAC. Now, you can identify these because typically they begin, as I say, with a hypothetical and sometimes faintly improbable facts and end asking you advise one of the parties, although sometimes you will be asked to discuss the liability of the parties. Again, don't visualize the facts as being real, rather focus on the legal rules and look at the principles which arise. The writing is critical. Please answer the question the examiners ask. Legal writing is about formality. If I ask you, what is your name? The answer is not Jennifer. It is, my name is Jennifer Housen. As such, when the examiner gives you a set of facts and the end, he says, advise X, the answer is not, misrepresentation is where a false statement of fact is made to one party, which then induces, etc., etc., and you go on. No, the answer is, what is misrepresentation? Yeah. So when you look at the answer you've just given, you've just answered the question, what is misrepresentation? Even if the question is about misrep, if the question asks you to advise X, the correct answer is in advising X, and so on and so on. Now, there's an American TV program called Jeopardy, and the idea behind it is that you are given an answer and you have to phrase the question. So, for example, the host says Queen Elizabeth II, and the contestant says, who is the Queen of England? Well, your answers should reflect something like that. When you read the first line of your answer, without knowing what the question says, somebody looking at your answer, blind to the question, should be able to look at your answer and know from, say, the first two paragraphs, or preferably the first paragraph, what the question was. So if, for example, there was a contract formation question, if my answer was, in advising X as to whether there is a validly formed contract between her and Y, it is necessary to consider the status of each communication passing between the parties. And what I would have done in that less than 2-line introduction is made you aware of X, made you aware of Y, and you will know that apparently some communication has passed between the parties and X needs to be advised as to the extent and effect of what has gone on and whether there is a validly formed contract. Be succinct, be precise, write in the third person. Now, that is my intro, and what I'm going to do next when we return, after we take this short break, is I will review 3 questions, and after the break, I will start off with reviewing a question firstly on contract formation immediately after the break.